Okay, hello everyone, I'm back. I always hate to say that I have a cold, but I think I may have succumbed to the germs of the little children. Sometimes I call them children of the corn. So, excuse me, it's not too bad at this point, thank goodness. But I'm just going to give you all a little potpourri of things. So let's get into this. And you can always fast forward through this if you don't want to hear me reading the notes, or you can go online and look at them yourself. You always have that choice. Nobody's ever forcing you to do anything. So, and if you're new here, welcome. I would like to think this is a warm, welcoming, friendly, happy place. And I'm very laid back, and while still trying to obtain a better quality in time. But in the meantime, hey, here we go. Yeah, so I want to draw your attention to the notes, the jail notes. And probably most of y'all have already seen or heard about it. I knew I'd heard about it, but now I see when Sarah and her new attorney, Mr. Owens, were arguing, and this was on August 26th. And let's see what time it was. It was at 4:52 p.m. So it says on 8:26, I heard loud yelling from the hallways. Upon further investing, it's bad typos. Upon further investigating, I realized it was coming from the briefing room. The briefing room was occupied by inmate Sarah Boone and James Owens. Due to the loud disturbance, I entered the room and informed inmate Boone and Owens that they are causing a disturbance. Owens informed me that everything was good, that they had a little disagreement. After inmate Boone interview meeting, I spoke to her about retrieving a grievance form. Inmate Boone informed me that she did not need a grievance form. So that's the main thing I wanted to get out of the notes. So that happened on August 26th. I wonder if that was the day that he was trying to play prosecutor and going through all of the stuff that they were going to go through, and she got annoyed and was trying to run the show. So was he yelling too? That's what I want to know. But anyhow, so remember, in the two different interviews with Court TV, and then the very last one I shared on the prior video, that was a local news station in Orlando. But remember, he said, I feel what I get out of it is that his intent was to go and perhaps help her reach a plea deal, which I have a feeling that would have been her best bet. But oh well, she ain't going to do that. I think we all already know that. And so after they had their little altercation and all that kind of stuff, or they're yelling, that's probably when he went home and said to his wife, I don't think I'm going to do this. And then I guess she ended up calling him, and he came back. But I'm just saying, if they were yelling down there, how is he going to really keep her under control? I don't know. But there's something that's interesting to note. Okay, so we're going to move on to the next thing. Okay, looks like Mr. James Owens is gathering up the players in this Sarah Boone trial. This was e-filed September 3rd, and it is saying that notice of appearance, co-counsel. So here we go. The team is, yes, that is thunder. Anyhow, notice is hereby given that Kevin T. Beck hereby enters his appearance as co-counsel to James Owens, Esquire, on behalf of the defendant, Sarah Boone, in the above-styled case. So there's Kevin T. Beck. So he's getting in the game now. Okay, so this is motion for statement of particulars. This was e-filed September 2nd. So this is motion for statement of particulars. Comes now the defendant by and through the undersigned attorney under Rule 3.14 of the Florida Rules of Criminal Procedure and requests this court to enter an order requiring the state of Florida to furnish the defendant with a statement of particulars concerning the alleged offense, including the following. Number 1, the defendant, Sarah Boone, is charged by way of an information with a single count of second-degree murder. 2, the pertinent part of the information states, charges that Sarah Boone, on or about the 23rd day of February 2020 in said county and state, did, in violation of Florida Statute 78204, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did unalive George Torres. Well, I would say that's probably about right. Number 3, under the Florida Standard Jury Instructions for Criminal Cases, 7.4, Murder, Second Degree, Section 782.04, to prove the crime of second-degree murder, the state must prove the following 3 elements let me reread that. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. So that's what they're looking for. Can they prove these 3 things beyond a reasonable doubt? A doubt, not about a doubt. It was a long day at school. What can I say? Number 1, the victim is no longer with us. Sometimes you got to watch out for these words on YouTube. Number 2, the unaliving was caused by the criminal act of defendant. Okay, number 3, there was an dear God, help me. So sorry, guys. Number 3, there was an unlawful killing of victim. Oop, I said killing. There was an unlawful unaliving of victim by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Okay, so here are the definitions. That's all, folks. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that one, a person of ordinary judgment would know is reasonably certain to unalive or do serious bodily injury to another, and number 2, is done from ill will, hatred, spite, or an evil intent. And let me just stop there. I mean, do you think that all kind of fits what Sarah did? I'm just asking. Number 3 is of such a nature that the act itself indicates an indifference to human life. Okay, guilty. I don't think we need to go on any further. Okay. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Interesting. Yes, we do have some background thunder. So it says, number 4, under Florida Rules of Criminal Procedure, a defendant has the right to know of the charges against them with specificity. Oh God, here we go again with my pronunciations. When I'm tired, I can't pronounce. Specificity. Oh my gosh. You know, specific. 5, upon request, the state must provide specificity. I can't say it. So sorry. When I get tired, I just can't say words. But you get it. You can read it. Okay, and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. Gosh, yes, please, for the love of everything that's holy, let's please make sure the defendant's rights are protected. 6. The rules require the information on which the defendant is to be tried shall be a plain, concise, and definite written statement of the essential facts constituting the offense charged. 7. The information fails to inform the defendant of the particulars of the offense sufficiently to enable the defendant to prepare a defense. Wherefore, the defense would respectfully request the court consider this request and grant the defense motion for statement of particulars. Okay, so there's that. Okay, here is a motion e-filed on September 2nd. And the motion is to appoint crime scene reconstructionist and unalive investigator. So yes, this was all talked about in court, but I'm just curious to see how that comes about. Comes now the defendant, by and through the undersigned attorney and moves this honorable court for the appointment of a due process provider to aid in the preparation of the defense in the above styled cause, and as grounds would show, number 1, the defendant is charged with second-degree murder and has previously been found indigent. We know that. Number 2, the undersigned attorney is privately retained and requests the assistance of a crime scene reconstructionist / unalive investigator to assist in the defense. Number 3, the defendant is financially unable to hire a due process provider, crime scene reconstructionist, unalive investigator to aid in the preparations of the defense, and therefore requires the assistance of the court to ensure the protection of her right to due process and effective assistance of counsel. Okay, number 4. The defense requests the court appoint Dr. Michael Birkeland, a crime scene reconstructionist, unalive investigator for the defendant. Number 5, Dr. Michael Birkeland is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform his duties, including time spent traveling. Number 6, the undersigned requests Dr. Michael Birkeland be appointed at a rate of $200 per hour for work and travel time with an initial cap of $6,000 exclusive of necessary costs allowed by statute. Okay, wherefore the defense respectfully requests the court appoint Dr. Michael Birkeland to assist the defense as a crime scene reconstructionist, unalive investigator. Don't you love how I do that? It's like if I whisper, it's going to make it okay. So that's interesting. I do remember that Peter from Lawyer You Know, and like I said, if you want to have a better understanding of the legal stuff, he said that was a pretty fair price to ask. So probably that will not be a problem. Okay, here's another motion. I believe it was also filed. Oops, let's not do that. On September 2nd. And this one is motion to appoint forensic psychologist. Comes now the defendant by and through the undersigned attorney and moves this honorable court for the appointment of a due process provider to aid in the preparation of the defense in the above styled cause, and as grounds would show, number 1, the defendant is charged with second degree M and has previously been found indigent. Number 2, the undersigned attorney is privately retained and requests the assistance of a forensic psychologist to aid in the defense of this matter. Number 3, The defendant is financially unable to hire a due process provider or forensic psychologist to aid in the preparation of the defense and therefore requires the assistance of the court to ensure the protection of her right to due process and effective assistance of counsel. Okay, we're to number 4. The defense requests the court appoint Dr. Julie Harper, a forensic psychologist, for the defendant. Number 5, Dr. Harper, sorry, my voice cracked a little. Dr. Harper is requesting and has been paid in other court-appointed cases a rate of $200 per hour to perform her duties, including time spent traveling. Number 6, the undersigned requests Dr. Julie Harper be appointed at a rate of $200 per hour. For work and travel time with an initial cap of $7,500 exclusive of necessary costs allowed by statute. Wherefore, the defense respectfully requests this court appoint Dr. Julie Harper to assist the defense as a forensic psychologist. Moving right along. Okay, so now I'm going to revisit this, the second half. The last video I posted has Vinnie Politan from Court TV talking to Mr. Owens, Sarah's new attorney. But now Vinnie's going to talk to 4, alleged experts to see what they think about everything. And they're also going to talk about, because I thought it was kind of clever that Mr. Owens here brought up the thing about George's brother. And they have an opinion, like if that's going to be able to be brought in and what they think and all that. I don't know. Do you think maybe he put it out there in case like somebody could be a possible juror, and they're like, oh, maybe the brothers are bad, which, yeah, maybe they are, but Sarah sure ain't no saint. Let's get real. That's the thing. And the other thing, too, I know that Attorney Owens said that Sarah had said that about dysfunction in the Torres family. Well, please, how about Sarah's family? And in the video where Sarah's ex, Brian, is interrogated by the police, he talks about how she can be kind of like, I think she's kind of, and I think he's a bigger man than what George and Sarah are, Brian. But I think that he said something about how she could be aggressive. So see, that's going to be a problem, I think. But I don't know, Mr. Owens already has another attorney aboard. But let's just listen to what these people have to say, what they think about the situation.
How about that, folks? Somebody stepped forward to represent Sarah Boone. James Owens is his name, really experienced attorney, but he's nowhere near Orlando. He's closer to Pensacola. If you know anything about Florida, you don't just drive. That's a flight. So he's stepping up. He's stepping in. Let's get some reactions, some perspective from our think tank tonight.
Excuse me.
Joining us, trial attorney, fellow of the American College of Trial Lawyers, Ann Bremner is with us. Also joining us, trial attorney, former police lieutenant Rick King, and the state attorney for Palm Beach County, Harvard Smarty, Dave Arenberg. Great to see everyone. Can I start here because I got 2 Florida guys here, but Dave, you can't do it. But Rick, do you want to be part of the team? You want to jump up to Orlando and help James out? He needs a little bit of help.
The one thing that he said, he said a lot of things that were right, but there's one thing he said was, in order to try to do something like this, you got to put the rest of your practice down. There's no way that you can come together from September to October the 7th without putting the rest of your practice down. And it's for me right now, that would be impossible. But big ups. I really give Mr. Owens a lot of credit, and I'm a lot of respect for him for taking up this cause because he's right.
He stepped up. He's stepping up. Yeah. Ann Bremner, are you, first of all, are you surprised that someone did it? number one, and are you surprised that they responded to me placing the ad here on closing arguments?
As to the second one, not at all. Everyone watches you, and that's what Mr. Owens just said, right? But I'm not surprised. I think he's a great guy for doing it. Like you said, our profession and the courts need this. But wouldn't the courts reimburse him through the public defenders payments that would be given to someone that appeared on her behalf through their office? I mean, I was just wondering about that because it's a pretty noble thing to undertake, but an expensive one.
Yeah,
that basically at the expense of his practice.
She's gonna be
expensive. But I think the judge appointed like 8 different lawyers at one point.
Right.
Dave Arenberg, I'm a former prosecutor, you're a prosecutor, but I think we all appreciate, as prosecutors, defense attorneys stepping in and stepping up. And I think it's going to help this prosecutor, even though it'll be a more difficult case. Yeah. It's just not going to be as messy. It'll be a little bit more organized, less kind of, being gentle that you need to be in the courtroom. You can just be yourself.
Maybe no prosecutor wants a circus, especially with a defendant like Miss Boone, who is high drama, who is very difficult to get along with. And I give a lot of respect for Mr. Owens for stepping up. But remember, this is a self-inflicted wound. This is something she did because of her conduct. She apparently wouldn't listen to her lawyers.
That's
She
right.
made it so difficult for them. They bailed on her. So when Mr. Owens says that, well, she has trust issues, look at yourself in the mirror, ma'am. You're the reason why
Thank you.
These people bailed on you. And maybe once she can realize that it's her fault. Right now, it seems like she likes to blame everyone else for all of her problems.
Yes.
Hopefully, Mr. Owens will stay around. But, we've seen this movie before where someone steps in and says, I can reform this person. I can change this person. I'll be the friend. And then people reveal their true colors soon enough, and then they end up like everyone else.
Yeah, but the difference here, I think Sarah Boone realized this trial is happening. It's not happening. Let me ask you, though, Rick, about the 4-hour initial meeting in the jail. Like, that's almost serving time if you're 4 hours behind bars with your client.
Honestly, my law partner, when she goes to the jail, she's in there for quite some time. So 4 hours, not really that bad, but it's a start for.
If you stay for 6, do you get to eat with the rest of the inmates? Like, how does that work? 4 hours is a long time.
I'm sure that would be lovely.
So let me play a little bit from today's hearing because James was looking for more time, and here's how it all went down.
It is critical to my theory, our theory of defense, Backus-Fowl syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on Backus-Fowl syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Finn, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. It involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still have to peel back all the layers. It'll take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go.
The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
You've met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order to the judge portion, that trial specially set for October 7th. 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel.
Dave Arenberg, are you surprised? Could this, if there's a conviction, could this be a problem on appeal?
Yes, this is my surprise. Look, I understand why the judge did this. The judge said no means no. He said, you're not going to get another extension, and we're not giving you another court-appointed lawyer. That's it. So her only avenue is to get her own lawyer, but it meant no extension. And now you have the new lawyer saying, I need an extension. So I get why the judge denied it, but you're risking fate here. You're tempting fate because you're saying that we're going to be so secure that our future conviction will be upheld on appeal that I'm not going to grant you one more extension. I would have just said, go ahead with it. Even the prosecutor took a more, nuanced view of this. I mean, they don't want a conviction being overturned on appeal. That would be the worst situation for everyone involved except for Sarah Boone.
Now, we heard James Owens talk about experts. All those experts are connected to his defense, which we believe they're going to attempt, if the experts agree, to a battered spouse defense. When we come back, we're going to talk about that and talk about the victim's history and the relationship here and the domestic violence that exists between the two.
Sometimes I'm not sure what I'm supposed to do. I'm afraid of it. I'm afraid of his family. My son can't come over here because he's here.
Well, why did she keep letting him back in? Yeah, they're going to play a few clips here and there where, if you were to look at it and not know anything about her, she does look allegedly more scared. I don't know why I'm saying allegedly. She is, in my opinion, she does look more scared. But let's see what these people say once we get back to it. Okay, they cut off for a commercial, then they came back. But it is interesting that she did say, I'm afraid of him. I'm afraid of his family. But come on, she's part of this circus too. Okay, let's see what she says.
Read that specific.
You didn't even include it at all.
Me and here, I saw white.
Okay, so he kicks the door open, jumps on top of you, punches you in the ear. Am I right? Or am I wrong?
No, you're right.
Okay, that's about 5 months before the suitcase incident where Sarah Boone is describing alleged abuse by her boyfriend, George Torres. Now, there is a history here, and George Torres has an arrest history. Take a look. June 15th, 2019, George is arrested for battery. June 18th, 2019, George is arrested for violation of a pretrial release condition. He was making contact with Sarah when he was not supposed to. Police were investigating something else and came across that. August 28th, 2019, George is arrested for battery as well. Then September 4th, 2019, George arrested for battery again. Now, September 4th, 2019, again, 5 months before the suitcase incident, we've got body cam video of this alleged domestic violence incident response by police. Take a look.
George was hiding in the bathtub upstairs. Okay?
Yes.
So,
Why was George hiding in the bathtub? Was he scared of Sarah? I mean, I do kind of want to know. I mean, it's, and you got to forgive me because this is nothing to laugh about, but it's so insane. Unfortunately, in dreadful situations, laughter seems to be my go-to. So, just ignore my dark humor because it's not funny, but it's just so incredulous, this crap going on.
he gave me his side of things. I need you to give me your side of things in person right here. I know we kind of talked on the phone, but I need you to tell me what happened tonight. So what happened?
It was pardon my language because it's not me. I was called a and
Okay.
and I'm not a mother to my son.
Okay.
All the while, nonetheless, I was sleeping before that.
Okay. So you're woken up to him calling you names. Is that what you're saying?
I thought that I'm like, feed the beast. Go outside and smoke a cigarette with him.
Okay.
Try to calm things. Well, the whole time I was there saying nothing. Nothing. I was called names.
Okay. So you guys were smoking a cigarette, and he was calling you names, being verbally aggressive with you. Verbally abusive.
Before that, where I'm like, I don't want to get hit anymore. So I'm just going to go downstairs and smoke a cigarette with him to try to calm him down.
Okay. So you're saying, okay, I'm trying to get a timeline of things. So start from the beginning and give me the timeline.
Was it I was asleep?
I don't, not literal time, but in a reference of incidents, how they occurred tonight.
I was asleep, and again, he comes in and wakes me up.
He wakes you up. Okay.
He's out of sorts.
Okay.
So I'm trying to figure things out.
Okay.
Where it's like, don't make it worse. Just go downstairs with him. Because he gets mad at me because I go to sleep.
Okay.
I go downstairs, smoke a cigarette. The whole time I'm being...
Well, can I just speak here? No wonder he gets mad when she goes to sleep. Look what happened the very last time she went to sleep around him. He ended up unalived in the suitcase. And she's talking so quietly. Are y'all picking up that the police officer is irritated with her? How many times have they had to hear her stories? And I don't mean that they shouldn't take them seriously, but come on, you know, she's, oh my God, she's a hot mess. I just wanted to point that out. I think y'all didn't need to point it out, but I just want to state my opinion. Here we go.
A little...
Okay.
Pardon me for saying talk about.
And then?
I walked off barefoot.
Okay, so when did he hit you? You said he hit you.
That was in the bedroom.
When? I just asked for a timeline.
He woke me up.
Okay.
He's asked for a timeline, Sarah.
By hitting you? Is that what you're telling me? Or what happened? I need you to tell me.
He kicked the door open. He's kicked the...
You're adding a lot of details that I need you to be very concise
just like
with.
her letters.
When I'm telling you, I need a timeline of the events.
Yes.
How am I going to corroborate your story?
He kicked the door open. 4 times. The fourth time, I gave in. Okay? That's when I got punched in my ear. On the 4th time. Where I was like, don't do it anymore. Just go downstairs. Go smoke a cigarette.
Okay.
And that's what I did. Okay. And then I walked off barefoot.
Okay. And on the phone, you told me that you attacked him as well.
I didn't attack him.
You said you exchanged, you had a physical altercation on the phone. That's what you told me.
I pulled him off of me.
He said he has marks because I was fighting for my life.
I was being honest with you.
Oh my gosh. Oh Lord.
So how does this play? What does this mean? Let's bring back in our think tank, Ann Bremner, Rick King, Dave Arenberg. Ann Bremner, are you seeing a battered spouse, a battered woman in this video? And do you think that this becomes relevant in the trial?
Well, I don't know if I see it or not, Vinny. I mean, the officer seems to not believe her, at least in my estimation, but she's definitely got that defense. And she called it in, and she said she was attacked and everything else. It sounds like it's happened before. So this is something that she can allege. However, he's in a suitcase. So, I mean, does she let him out? You know, does she call the police, say, I put him in a suitcase to protect myself? No, she leaves him all night, and then it's tape recorded where she's saying, I'll teach you to cheat on me, things like that. So, I mean, the first case that we had on battered women's syndrome was the Thacker case, started in 77, ended in 80 in Washington State, that allowed for this defense. And it's relatively new. I think it's important for battered women. The question is, was she?
Okay, Rick King, let me put this up on the screen. This is from June 15th, 2019. The suitcase incident is February 2020. Sarah stated she was beaten up, face, head, legs, arms. She stated she begged George to stop. George stated, you're going to die. Sarah stated that George punched her in the head, flung her off the bed. Sarah stated the incident occurred due to George being upset about Sarah talking to a male. Do you think there's going to be enough here for a battered spouse, battered woman syndrome type of defense?
I mean, I think you could make the argument based on the history of battery from George to Sarah. However, when you think about the statements that she made post when the police arrived there, talking about, and the video, moreover in the video, talking about you cheated on me and then the hide and seek defense, all those things seem to undermine the theory of the defense from that perspective.
Dave Ehrenberg, something else that we've now discovered is George Torres's brother, Pharrell Torres, apparently being charged with murder. This is from May of this year, May 29, charged with homicide without premeditation. He called 911, stated in the call, "I stabbed her in the head." He said multiple times, "I stabbed her because I was mad." Police arrived. They found Pharrell Torres' girlfriend face down on her stomach, pool of blood around her abdomen on the floor, turned to the right, steak knife sticking out of the right side of her face. Ugh. That's George's brother. Does that have any relevance at all to this case?
No, that stuff's coming in, Vinny. That's not going to happen in this case. Unless some jurors see this elsewhere and then bring it in with them, and that would be violating their oath. But to get what Rick was saying, I agree with him. I think it's going to be hard for her to really push this defense because her words on the video she recorded showed that she was the one taunting him, being mad at him for various things. And yes, even if he did lay hands on her, which apparently they both did to each other, you can't just go around killing people because of previous conduct. You have to be in imminent fear of your life at that time. This guy was locked up in a suitcase. She was taunting him. So I think the self-defense claim, the battered spouse defense, I think that falls flat. The only
Could she claim that if I let him out, I was scared of what would have happened if I let him out of that suitcase?
Yeah, she could try to claim that, and that may be her best defense, is to say I was drunk, number one, so I don't have the required elements of mens rea for murder, and I was worried, and maybe then you can get a manslaughter conviction. She is not walking free. She is not getting acquitted in this case, but there's a possibility she could get convicted of a lesser offense. I think that's the best thing her lawyer can hope for.
And Bremner, what do you think would have happened if she let George out of the suitcase?
Depends on when, right, Benny? I mean, it depends on if she waited till the next morning or if she did it that night. But I think maybe he would have attacked her, wouldn't you? I mean, if someone put you in a suitcase like that and taunted you, based on his prior behavior. So that's a good argument, basically, that if he got out, he would have hurt her, and so she couldn't let him out.
Rick, are you shocked that this is going to trial? That they couldn't work something out?
Yes, I'm very shocked that it's going to trial for a couple of reasons. I'm shocked that first of all, they didn't grant the continuance. I really am. I agree with Mr. Ehrenberg on that they should have. I feel like just in the furtherance of justice and for her to fully appreciate her Sixth Amendment right to counsel, that they should have given a continuance. But I'm also shocked that there wasn't some sort of plea offered in this that was acceptable to the defense and to the state.
Great insight tonight, as always. Ann Bremner, Rick King, Dave Ehrenberg, thank you all so much. We'll see you again very soon, I'm sure.
All right. So I think that they're, they say they're shocked that they couldn't come to a plea deal. Don't you think? Well, this is my opinion. I think it's because Sarah didn't want to. Like I said, this is just my thought, of course, because as I've said before, I'm not an attorney, paralegal, psychiatrist, psychologist. Just somebody who's interested in true crime and is curious and definitely has an opinion. I think, like I said, I think my thoughts is that Sarah is an all or nothing kind of gal. She really believes that she's right and that she should be out. I mean, just think about it. She went into that horrendously long interrogation, didn't get an attorney, and really felt like, she was going to get to go home. I think because she felt she was so forthright with everything. But obviously, probably forgetting that she recorded what I think, as I call it, the gold ticket. So, everyone does seem to be talking about, though, that they're surprised that the judge did not give her, or not her, but, for her and her attorney, a continuance. So hopefully, though, he has kept good enough records that it won't be an appellate issue. Oh gosh, I don't think I could mentally handle it. I don't know about you all, but I know I've told you all I've watched different people like Lawyer No, and then there's Dr. Barry, the psychologist who's really good. She covers some of Sarah Boone, and she seems to be consistently impressed by the judge because she says she thinks the judge does an excellent job of setting boundaries for Sarah, because and I totally agree, because he stays very even, and every time she'll go, it's not fair, and he goes, I understand that that's, how you feel, but he's not like letting her break him. So hopefully he is doing everything he can. I mean, I feel, of course, I'm no expert, but I feel like that he is. I mean, how many times can anybody take Sarah? And I'm still wondering, is something going to happen with her and these attorneys? Tell me down below what you all think. And I think this is enough for now. And I'm sure there's going to be more coming up, but sorry for the delay on the other video. Hopefully I can get this one up. Hopefully tonight, where you can even see 2 in one night, or spread it out if you want. But that's it for now. I think that covers some things, gets us up to date. And so, as always, thank you so much for subscribing, liking, commenting. And if you haven't subscribed and you think you kind of like it here, it doesn't cost you a thing to subscribe. I'm trying to get to the big 3K, so I would greatly appreciate it. But I love you all. Be kind to someone. Be kind to you. And I'll see you the next time.